Yes, Mr. Green.
May it please your lordships, I appear on behalf of the applicants with Mr. Andrew Stafford, King's Counsel, who's generously affording me a bit of extra bench space, and Mr. Richard Clark. Learned friend Tarek Ballock and Cameron Miles appear on behalf of the Kingdom of Spain. My lord, there are, I think, 3 points I need to deal with, overarching points. The
Just before you come to the 3 points, just let me put my house in order.
My clerk's still trying to work out how to get us onto the transcript.
Okay, but I'm with you anyway, if my lord is...
Well, I don't know what's happening.
Okay.
Don't know whether the
Just wait a second.
Yeah, is there somebody who knows how this works in court? Could one of the... Can you possibly...
In theory, I do.
Yeah, if you could, that would be very...
Oh yeah, you double click on hearing.
Yeah, okay, nobody's told me of any links, so I can't follow it.
Good, thank you very much, that's very kind. Okay, sorry about that. Thank you.
I don't know if my Lord Justice Snowden would like a link to the transcript as well.
Yes,
It doesn't seem to have reached.
I haven't been given one.
I haven't got
Don't
a
worry.
link,
No,
but
I will send it on
I'm
to
going
you.
to live without it.
We normally don't do it
I shall
live.
do something unheard of in judicial terms. I shall listen to you, Mr. Green.
Oh, Lord, I'm very grateful.
My lord will memorise all your submissions.
Well, I'll have to make them even shorter.
Yes.
I'll do my best. My lords, I think I've got 3 things I need to deal with. The original challenge to jurisdiction mounted by the Kingdom of Spain, which was based on Rule 5218, and that was as expressed in the letter that we have, which I'll take the court to in a minute, at H1216.
What?
The hearing bundle, page 1216.
That's not really pursued, though, is it? Is this the point about
Well,
the hearing?
Yeah, it's the point about the hearing, my lord. I'll hope to deal with it quickly.
Yeah.
The second point, I just enumerate what the points are.
Yes.
Apologies.
Yeah.
Number 1 is the original challenge.
Yeah.
Number 2 is the new challenge in the skeleton, which obviously, as it was unheralded, we haven't addressed in our skeleton. And then number 3 is whether there's a compelling reason to make an order. And I'm happy to spend as long or as little time on the first 2 as the court would like. I'm very happy for any indications that would help me fine-tune how long to spend. But I think that,
Well, I mean, it's a bit illogical for you to be
responding.
opening in
Yes.
response.
Yes.
The logical order, I would hope you'd have talked about this, but the logical order is for Mr. Ballock to open his challenge to jurisdiction.
Yes.
And say why, and likely touch why there's no compelling reason.
Yes.
And for you to then respond on jurisdiction and open on compelling reason.
I'd be very happy with that order, my lord.
What do you say, Mr. Ballock?
My lord, whatever is helpful to your lordships, that does make sense, and we're happy to do that.
What do you think? You agree?
Yeah, I agree.
Yeah, okay. Well, we all agree up here, so Mr. Ballock, you
If I may just be permitted a minute just to organise myself and put my house in order. My lords, your lordships have our skeletons, and I would hope you also have 6 volumes of bundles, 3 which I'm good hearing bundles H1 to H3. And
I've got 1 electronic bundle.
Right.
You
Okay.
can call it what you like, but it's
Yes.
got 1,237 pages.
Right. Okay.
If you refer to the page number that would be very helpful to me. I don't use paper.
Right. Okay.
I've got an authorities bundle, and that's all else I've got.
My lord, you'll be happy to know that I will be referring to the page number. I was also going to refer to volumes, but I will try and avoid that.
You can do that,
Yes.
because it'll help my lord. But
Okay.
If you refer to the page number, if it's the printed, it's the classic situation. If you refer to the printed page number, you'll need to add 4 for the electronic page number.
which is something your solicitors can take note of for the future, because it should not happen.
Understood, my lord.
When people prepare the bundles and then prepare the indices afterwards, forgetting that they go at the front in the electronic bundle and add therefore 4 pages to the e-number.
Maths was never my thing, but I'm going to try and remember that and add 4 each time.
But don't worry,
Okay.
we can sort it out,
Yeah.
as long as you're consistent.
Thank you, my lords. My lords, so let me open Spain's case, my lord, on this application that's been made. This is a case about whether you should reconsider Lord Justice Mayles' decision to grant Spain unconditional leave to appeal and make that leave to appeal conditional on Spain paying in the award debt or another sum. Now, Lord Justice Mayles' decision was made pursuant to the respondent's first application for conditions, which he rejected. The respondents are now
That's a
asked...
slightly tendentious way of putting it, isn't it? I mean, it's the question we have to decide is, was that an application with which Lord Justice Mayles dealt?
Yes, my lord, and
So
I will
to
be
say it
addressing
was
that.
made in response to their application is tendentious.
And we understand the
unhelpful.
way in which you put it, but it doesn't really answer the question we have to answer.
Exactly.
My lord, so but you obviously have, your lordships, the hearing order, what we call the hearing order, which came after his order rejecting.
Yes.
And that he
25.
explains, yes. And my lord, I will be, I'm just summarising our case, but I am going to take you, and I can do it straight away. I just wanted to put a structure in front of you and then explain to you why we believe it was an application initially. And as I thought, it was rejected, but I will explain that to you. My lord, Spain has raised what has been described as jurisdictional objections. There is a debate between the parties whether these objections are jurisdictional or whether they are procedural bars. My lords, in my submission, nothing turns on this language, because ultimately Spain's point is that these are primary hurdles which the respondents must clear before the relevant provision under which the application is made can be considered. And not clearing these preliminary hurdles means the application can, we would submit, be dismissed at the outset. And a more neutral word to use perhaps then is a preliminary objection. My lord, my submissions will be structured as follows. I will begin by setting out Spain's 2 preliminary objections that to what we have called the respondent's second application for conditions. Its first, as I said, we submit that was rejected, and I'll explain why. As we explained in the skeleton, Spain has raised 2 further preliminary grounds, but these are no longer the primary basis for Spain's objections. Spain accepts that both those grounds require the court to make new law, and this is not necessary to dispose of this application. So unless
Do you raise them, do you ask us to deal with them, or do you not ask us to?
I don't ask you to deal with them, my lord, and I will not be dealing with them in my oral submissions. I'm focusing...
We've got them in your skeleton, we know what they are.
Exactly, my lord, and I wasn't going to spend time on them, because in our submission, the 2 that we have focused on are sufficient to dispose of, we would submit, the respondent's application. So, my lords, the first and preliminary ground is that the respondents made their second application under the wrong provision. They made it under CPR 5218(1)(c) and out of time. They should have sought reconsideration under CPR 52.24 sub 6 within 7 days of Lord Justice Mayles, we say, rejection of the first application in the PTA order, and I call it the PTA order, which is the order in which he granted leave to appeal. They did not do so. The
So
second...
24, I'm sorry, I just want to have it in my mind. 20, what page is 24? 52, 24, 6.
Yes, my lord.
Is it
A32.
32? Page
Yes.
38 in the electronic. The party may request the decision of a single judge made without a hearing to be reconsidered. Okay.
My Lord, I'll be taking to that. I'm just summarising my submission, my Lord.
Yeah.
That's our first submission. My Lord, the second preliminary ground is that even under the provision the respondents rely on, which is 52.18.1c, this court should not consider the second application because the case law shows that conditions under this provision cannot be granted based on facts known at the time the permission to appeal was granted. And it is common ground that the respondents knew of the Luxembourg proceedings, as they are called, at the time of the first application. And in this section, I will also explain that the respondents cannot be excused for not mentioning the Luxembourg proceedings on account of space, as they maintain. The chronology shows that they could and should, if they wanted to rely on them, have mentioned the proceedings earlier, but positively decided not to. And finally, Your Lordships, if you are not with Spain on these preliminary objections, I will address the second application on its merits and show you that conditions are not, in any event, justified. In this section of my submissions, I will show that the critical and important principle of finality means this court starts from the position heavily weighted against revisiting Lord Justice Mayles' original order declining conditions, and that further there are no compelling reasons in this case to displace the principle or the dead weight of finality, as AIC puts it. My Lord, against that background, and before starting on my main submissions, I wanted to make just three brief overview points on the substance. My Lord, first, it is important not to forget the ground rules, so to speak, if I may say so, set by Lord Justice Mayles for this hearing in what we have called the hearing order. And if I could invite Your Lordships to go to that, in the paper bundles, it's page 1123. This is in the hearing bundle.
Which tab is it?
It's tab 25. And I suppose you add 4 to that, my Lord, so it's 1127. That's tab 25.
Yeah.
My Lords, you have that? Yes. My Lords, if I can ask you, when you look at that, in paragraph 1, Your Lordships, you will see Lord Justice Mayles confirmed that he did not deliberately grant conditions when he granted permission on paper. In paragraph 2...
How are the parties supposed to know that?
My Lord, we would submit that it's actually obvious from his initial permission to appeal order, the PTA order, because they asked for conditions and no conditions were awarded. So it's an unconditional grant.
So when you say they asked for conditions,
Yes, my Lord.
if you look at the respondent's brief statement,
Yes.
they said if the court were minded to grant permission, the respondents identify the following condition to which they contend the appeal should be subject.
Yes.
Is that an application before the court?
My Lord, we would say it is, and I will explain why. I can get to that now. I just wanted to give you the 3 overview points.
Okay.
And I totally understand that that is something...
You might also want to, if you go to the actual PTA order, the only application that's actually mentioned by Lord Justice Mayles is the application for permission to appeal.
Yeah, at the beginning of the order.
My Lord, but...
He doesn't say.
In respect to an application.
He doesn't say I'm here. I'm considering an application for permission to appeal and an application for security to be ordered.
But my Lord, we take on face value what he said in the hearing order subsequently, where he said that he did have the conditions request in mind.
But as the Master Rolls has put to you, how are the parties supposed to know that just looking at the actual PTA order?
Well, my Lord, what we will submit, and I'll come to this first, that when you're making a request for conditions and the permission comes back without those conditions attached, that is the natural construction. But secondly, if you're not clear, then you ask for clarification. And in fact, before this hearing order was even directed, my learned friends and the respondents had already made their application under 52.18.3, so they knew that they hadn't been given conditions and it had been rejected. They didn't say, we're not clear, can you please consider our application?
Well, how do you say they know it had been rejected, as opposed to them wishing to make a formal application for something they'd intimated earlier?
Well, that, we say that's a natural construction because if they weren't clear, they could have written to the judge and said, we're not sure, we did make an application, or we requested conditions and you haven't given it. Can you please clarify? They didn't wait for that clarification. They went ahead and made an application. And if they were not sure, then the answer, my lords, is, well, maybe you've forgotten in their minds. Please, can you go down the 5224/6 route and reconsider the application because you didn't consider it the first time? But that was not done. And I will take you through the chronology.
It's implicit in 5218(3) that if there isn't a hearing at which permission to appeal is granted, it's open to somebody to make an application for the imposition conditions after the permission to appeal has been granted. I mean, the problem, I suspect, is that this rule, or these rules, have not been fully brought up to date since the introduction of, effectively, or the abolition of oral renewals, other than in very limited cases.
That may well be the case, my lord, and the emphasis on
but,
paper.
I mean, what this rule, 5218(3) appears to contemplate is if there hasn't been if permission is given on paper, somebody can apply for the imposition of conditions after permission is given. But
But I mean,
that's the argument against you, I suppose.
It is, my lord. And so there are really two routes. One is to say we're going to go straight to 5218(1)(c), and we say that's not the right route. The right route is to go back to the same judge, because the scheme is, as far as possible, consider things on paper unless you want to go down the oral hearing route. And there is specific provision saying if you want that judge to reconsider, then apply down 5224(6), and there's 7 days to do it.
But equally, what's said against you, one of the things that's said against you is if they've done nothing at all. They said nothing in their PD 52C19 statement.
Yes.
About conditions. It would have been open to them to make an application.
My lord,
5218(1).
quite right, my lord. That we accept that if you're not going to request it in the brief statement, then you could wait until the decision on appeal on the permission has been granted, and then go to 5218(3). That at least sits consistently with the way the scheme is, because we need to give. Well, you don't have to, I suppose, and your lordship may decide. But 5224(6) is there for a reason. It sets a time limit. It's consistent with a scheme that wherever possible, judges should, on issues like this, decide the matter on paper.
You said repeatedly that this was a request. If you actually look at the practice direction in 52 CPD 19, first of all, it's the respondent's statement is supposed to be not more than 3 pages long and should be directed to the relevant threshold test. And then it just says under C, the statement should identify issues to which the appeal should be limited and any conditions to which the appeal should be subject. It's just it's an identification provision. It's not a request. Where does it say request?
Well, my lord, if you're saying in that, as we say they did, and I want to show you the chronology, that later on they said we've actually got a choice. We can either make a request here, or we can
No,
make
it's not a request. They identify. I mean, the practice statement, practice direction suggests that in the limited 3 pages, you should identify, but it doesn't say apply for. It doesn't say request. It says identify.
My lord, but it would be a rather useless thing to do if it's not going to be a request. The judge will say, what am I supposed to do with
Well,
this?
no. Why is it useless? The judge can then say, okay, I see that they wish permission to be subject to conditions. Right. Either I can dismiss that out of hand now summarily, because it's just nonsense, or I can give some directions for the necessary filing of evidence, and for there to be then a determination either subsequently on paper or at an oral hearing. In other words, it's to give the court a heads up that there's something other than the threshold test, which is the main purpose of that, to be considered.
My lord, but if even if one doesn't call it a request, you are stating that you would like conditions attached.
It's a heads up to the court just to say, okay,
right,
there's this issue as well, but you can't expect people to identify in the 3 pages that they're told they must limit themselves to sorry, to actually include in that 3 pages not only why permission shouldn't be granted, but also all the material that might be necessary for the sort of grant of conditions.
Quite right, my lord. So we say 2 things to that. The first is that there is nothing, in fact, in the practice direction that says that further evidence can't be submitted.
Well, it actually says that any evidence would be exceptional.
Yes, but and the second, my lord, so we don't think that there's a prohibition. But secondly, my lord, as you say, if you put in that paragraph that we would like to have this appeal, conditions attached to the appeal, that then tells the judge, well, they either reject it or accept it, or say, we would like further information on this before I give my decision. And we say that that request was considered, because that's what Lord Justice Mells tells us in the hearing order. And then the question is, well, if you're not happy with that, because he has considered it, he tells us, then what do you do next?
Well, he didn't actually tell anybody in the PTA order.
Right, and my lords, you may take the view that that was wrong, and if that's the case, then and it's the equivalent of no request or whichever word we use being made, and it hasn't been considered, then you can go straight to 52.18.3.1c. But we say that if it has been considered and rejected, then the next step is 52.24.6, not 52.18.1c.
I think we've asked you a lot of questions.
Yes.
I think what we should do is just lay low for a minute and let you develop your points. Now, I think you hadn't even finished before
Yes.
we all laid into you
My lord.
3 overview points.
Yes.
So can you give us those 3
I will,
points?
I will, my lord.
And we'll promise to take a vow of silence.
This is helpful to know which you're thinking, my lord, since I can emphasise those points. My lord, what I was just pointing out was that what the document that gave the directions for this hearing, what we have called the hearing order, sets out what I said were the ground rules. The first was, and this is what started the questions, what Lord Justice Mells thought he was doing when he granted permission to appeal. Let's put it like that, neutrally.
Yes.
In para 2, he says he was not then aware of the Luxembourg proceedings, which the respondents say are an anti-suit induction. He says this may have resulted in a different decision based on the case he there mentions, Mantovani, and I'll come back to that. He accepts that the Luxembourg proceedings were known at the time of the first application, but he says the respondents may have a point as to why they could not mention it. And I will tell you, my lords, why we think they could and should have mentioned it, even in a brief statement. And at the end, he sets out the questions for the hearing. And I say all this because it is clear that the focus of this hearing, at least in Lord Justice Mells's eyes, should be whether, because of a procedural bar or on the merits, the Luxembourg proceedings, if I may use a colloquialism, move the needle when it comes to imposing conditions on Spain's permission to appeal. This is not supposed to be a wide-ranging consideration of factors like the ICSID or mucular reason that's given by the respondents, because we say that's already been considered, and in any event, I will deal with it. My lord, that's my first point about the ground rules and the focus. The second point is that the respondent's second application, we say, is misconceived, because we say it's made under the wrong provision, fails to accept that it is an application for reconsideration of Lord Justice Mells's decision on condition, and ignores, whichever route you take, whether we say ignores the finality principle and proceeds on the basis that you can assess de novo the second application as if the first application was not made. Now, as I will show, this is just not how the procedural regime works, and I'll go through that with you. And thirdly, my lord, and this is more factual and on the merits, I think it's important to emphasize 2 facts that may get lost in the submissions and evidence, but which we say have a major impact on the merits of the respondent's case. The first is that Spain has, in correspondence, offered to stay the Luxembourg proceedings until the appeal is resolved. The respondents have utterly failed to engage with this undertaking, which Spain makes to this court as well, if my lords, you believe that the Luxembourg proceedings provide a compelling reason to impose conditions. We say they do not, and again, I will address you on that. They have also not discussed their undertaking.
Could you give me a reference for the offer?
Yes, my lord. I'll get it for you, my lords. My lords, no doubt, because this undertaking completely undercuts, we say,
1235.
the risk. What's that?
1235.
1235, my lord. As I said, I'm going to come back to that, my lord, and take you through it. This undertaking completely undercuts the respondents' arguments about the alleged threat and interference of the Luxembourg proceedings and the current proceedings in this jurisdiction. Because if the undertaking is accepted, that so-called interference would not be possible because there would be no appeal to interfere with. Or to put it in the words of the respondents, the Luxembourg proceedings could no longer be described as an anti-suit injunction because there would be no suit in this country to injunct because they would be suspended. My lord, all this is quite apart from the fact that even on their own terms, the Luxembourg proceedings do not provide a compelling reason to impose conditions for the reason I'll explain. They are pursuing legitimate EU law rights that have even been recognised.
So have you asked them whether they're prepared to abandon their application for conditions on the premise that you stay the Luxembourg proceedings?
Quite right, my lord, we have.
Expressly, and they have refused.
They have not answered. They've just said we will take instruction, and they've not answered.
Well, what's the answer?
My lord, the way it was
Obviously,
presented,
no, Mr. Green.
but the answer is no, that hasn't been accepted, and I can explain why.
No, it's okay. I just wanted to know.
Yeah, if it's helpful for the court to just see the two letters, there's one at paper 1231, electronic, I think 1235.
Yeah.
At the back of bundle 3 if you're on hard copies.
Yeah.
Tab 38. And that was the night before their evidence was due, wanting an immediate response.
Okay, we don't want. I wanted to know only one thing. Today,
The answer is no.
if the Luxembourg proceedings were stayed, would you accept that you didn't need to pursue this application? The answer to that, I think, is no. Thank you.
My lord, the second fact is that in the respondent's eyes, they already have a form of security over an asset they believe is valued at close to the award sum. This fact, again, was not properly brought to this court's attention, with the respondents carefully describing the interim charging order they have in this country over a large Spanish asset as being high value. My lords, high value can mean 1 million, 10 million, 20 million, or something in between. It does not tell you just how close the value is to the judgment debt in the respondent's eyes. In fact, the exact words from the charging order witness statement used by the respondents in the charging order proceeding is that if that property was sold, and I'm quoting them, it would be sufficient to satisfy the substantial portion, if not all, of the award debt.
Well, they don't actually specify how much the property is worth. There's no valuation on it.
No, my lord, but those are their words.
Is it? I mean, is it really suggested it's worth 120 million euros or whatever the?
My lord, I can take you to the witness statement. They believe.
I read it. But
Yeah.
I was just slightly surprised at the suggestion, even in North Kensington, that something is worth 120 million pounds.
My lord, it's a large building.
It's a large former Dominican convent.
Yeah, and my lords, of course, as your lordships know more than I do, it's not that one has to have the full security, but they are secure, even if you don't think it's.
Well, we're not going to act as experts as to the value of convents in Kensington, but we've heard that submission. Please proceed.
Okay.
So, my lord, on the respondent's case, therefore, they already are fully or close to fully secured, and they are using this application to improve their position. And we submit that is not the proper way to use the conditions jurisdiction. My lord, turning to Spain's preliminary grounds, and the first one, and you've asked me a lot of questions on it, and unless you already are clear in your views, I don't have to focus on that.
I'm not clear in my views.
Okay.
No.
My lord, so may I take you through it? And my lord, can I just say this, based on the questions you've rightly asked me and questions we've asked ourselves, I think things will become clearer. We know what the rules are if I take you through the chronology, and then it really is a matter of construction as to how you think the two rules should interplay.
Yeah.
You're absolutely right that this lacuna or gap may be the result of what happened in 2016, where the default was changed to paper consideration and only did as a matter of discretion oral hearings. And even that clarification by your lordships in this judgment, whatever you decide, would be helpful. So, my lord, as we say, and what we call the second application was made under the wrong provision. And I'll explain to you why we think it's an application, the first one.
Sorry, you call the first application
The brief statement,
the
In
paragraph.
the 5219.
exactly, my lords, in that paragraph. And we call the second application the one that's before you today, your lordships. My lord, I've taken you to 5224.6. As I said, my lords, this is a dedicated provision asking the court to reconsider a decision made by a single judge on paper, other than that judge's decision on leave to appeal. And that is precisely, we say, what is happening with the second application, which asks this court to reconsider what Lord Justice Mells thought he was doing when the request, or if we use another word, the statement in the brief statement was made about wanting to add conditions to the grant, to the leave to appeal. A party has 7 days, that's under 5224.7, and the respondent's escape route from this provision and the deadline it imposes is its claim that the first application was not, in fact, an application, but akin to an informational statement, we've called it, leaving the court to do what it pleases. My lords, the respondents also do not seem to accept that their application is asking this court to reconsider Lord Justice Mells' decision to grant unconditional leave to appeal. That obviously matters, because if our characterization is correct, then the principle of finality does definitely kick in.
Do you say,
Yeah.
looking at 6, do you say that the decision is not excluded insofar as it rejects the condition implicitly, you say?
Yes.
Do you say that it is not a decision determining any application for permission to appeal? Because on one analysis, this doesn't actually allow reconsideration of an application for permission to appeal, and this was an application for permission to appeal.
My lord, I think the way we read it is that 5224.6 says that there may be a series of decisions that are made that you may have requested. What you cannot ask him, or the judge or her, to reconsider is the decision on appeal, and he has given appeal. But you can ask him to reconsider what else you may have asked him for, which is, in the present case, we say the condition that a full payment should be made.
Okay.
My lord, if I can now take you to the what we call the first application, and that is the first hearing bundle, and tab 4. I think you already have it. And it's page 47 of 51 in the electronic bundle.
Yes.
My lord, your lordships have this in mind. This is where we say the first application was made, and I'm going to tell you more about why we say this is an application. It's certainly a request or an ask of the court that if the permission is going to be granted, then the respondents would like conditions to be added. There would be no other reason to put that there. They're asking, we say, for conditions. Now, Spain's solicitors, when this brief statement was made, wrote back and pointed out that the application for conditions was unheralded. They hadn't discussed it with us, and we also said, Spain's solicitors also said that this request did not meet the test for compelling reasons. Now, the respondents then responded to that, and
Sorry,
I want to take...
just before you go on, I know we were suggested, but are we actually going to look at what they said?
Yes, my lord, I'm happy to look at what they say, yes. But I want you to look at this and the subsequent letter and read it together. And
Okay.
we say, when you read it together...
I was going to look at this and read it together with the 52 CPD 19 1C,
Yes,
which it clearly refers to.
yes, my lord.
Yeah.
I suspect my lord's point is that this is doing precisely what the rule indicates you should do, which is identify the conditions you want.
Yes, my lord. But my lord, if then a decision is made on whether conditions are imposed, the question is, what do you do?
Well, you take your
Yeah.
own course, but
No,
my lord obviously we would like to see the response to this.
Yes. My lord, is your lordship's question that they're just doing what the PD says? I don't disagree with that. I suppose what I'm saying is what happens then if a judge looking at that says, actually, I'm not going to give you conditions, or in fact, I'd like to hear more, then that is a consideration of what has been put in the brief statement. And the question then is, what should one do once they've made a decision on that? And then that is where the two routes come in, 52.24.6 or 52.18.1c. My lords, as I said, when this request was first made, or this was stated in the brief statement, the Spain solicitor said, we do not think this meets the test for conditions. And then we have the respondents responding to this and explaining, well, not explaining. And if I can take you to tab 31, which is page 1206 in the paper bundle, and 1210 in the electronic bundle. My lord, if you turn to page 1206 and 1210, so as I said, Spain had pointed out that the brief statement, what had been requested, did not meet the test for conditions in the jurisprudence. This was the respondent's response. We can read it together. Secondly, the brief statement...
Where's the... This is from the respondent's solicitors.
Yes.
Where's your original
My
letter?
lord.
Is it in the previous tab or what? Where's the letter in which you... Because this is presumably...
My lord, our response to their brief statement is in tab 28.
Right.
And you can look at that. It's page 1137 in the electronic bundle, or 1133 in the hearing one. So you'll see there, we say, we've looked at the brief statement, it's unheralded.
This is before the judge decided.
Yes, before the judge decided.
Yeah.
We've looked at it, we don't think it provides a compelling reason. We set out the various cases very briefly, and then we also explain in paragraph 10, and of course I will be developing this when it comes to the merits, why we think the Mikula reason that I've called does not support the imposition of conditions. So that's what Spain said in response to the brief statement. And what I wanted to then show you was what the respondent said in response. And that's at tab 31, page 1206 in the paper bundle and 1210 in the electronic bundle. My lord, if it helps, I'll read it. Secondly, the brief statement complies with the requirements of the practice direction, which is what Lord Justice Snowden has mentioned, and I think all of you are, and we do not disagree with that, identifying any conditions to which any permission should be subject, in this case, provision of security for the laws. Neither the rules nor the practice direction require the arguments or evidence relied upon to be developed within the brief statement, which is limited to 3 pages, and is primarily directed to the reasons why permission should be granted. And my lord, the words in the parentheses are also important, because what they show, the respondents are also able to make an application, So we construe that, your lordships, as very much the respondent's understanding that they have 2 routes at this stage. When they are faced with an application for permission to appeal to the Court of Appeal, and it goes to a single judge, you have a choice.
Why do you
say that?
Well,
That's not what they're saying at all. I mean, it seems to me what they're saying very clearly, hence the underlining of the word identifying. I mean, they're making exactly the same points as they continue to make in this court now.
Yes.
Which is that they identified what conditions they thought should be imposed, but they make the point that if the court were minded to go down that route or wants to consider that, they'd want to put in further submissions and evidence.
Well, my lords, I'm not sure that it says that they're going to put in...
well, that's why they say, isn't it? Neither the rules nor the practice direction require the arguments or evidence relied upon to develop within the brief statement.
My lords, we do not... Our position actually is that the practice directions also don't preclude you from putting evidence in.
Well, it does, because if you look at what the practice direction says about putting in of evidence. It's actually not. It's not putting in evidence on this point at all.
No, but that doesn't mean you can't put it in, my lord. You can already see in the correspondence we're already arguing that what the relevant law is. We've already put in Spain 2 pages. They have put in 1.5 pages where they could have developed it. But my lord, I can answer this point a bit more simply, if I may. What I'm pointing out is that in the brackets, the respondents are also able to make an application for imposition. The also, we say, signals that this is what this request or this statement in the brief statement was also an application.
They can do both.
Yes, they can do both.
So why
Both
what I'm asking
identify
is
well-
why can't they do both?
Well, that's the point, my lord. So the question really is, instead of focusing on the start, where do we end up? If the judge, as we say he has, and he's clearly said so in the hearing order, has said that I've looked at your brief statement and I have not deliberately given you conditions, the question then is what's the next step? And that's what the debate is. And we say that next step should be 52.24.6, not 52.18.3. That's really the debate.
But isn't that problematic? Because the question of permission to appeal is ex parte,
Yes.
effectively. And the question of conditions is accepted as being inter partes, because the rules, the PD accepts that evidence may be necessary, not in every case, but it may be.
Yeah.
So prima facie, it is inter partes. And if you're right about the construction of sub-rule 6, then it's only permission to appeal that you can't take on. You can take on conditions.
Yes.
So the problem arises, doesn't it, because of that dichotomy. Now, it also, if that is right, then there's a problem in saying that they can't then apply for conditions after ex parte their application has been rejected. Because it's envisaged, it's an inter partes matter, so it's like applying for an ex parte injunction. You don't get it, but it doesn't inhibit you from bringing the matter to the court again inter partes.
My lord, but the application asking, there is an exchange here, initially, albeit a very brief one, a brief statement and our request for, Spain's request for permission to appeal. On reconsideration, there is nothing stopping the party from putting in their evidence and the further documents, and presumably we would then have responded in the normal way.
So you say the inter partes is on reconsideration?
Yes, yes, my lord. And there is nothing to stop that from happening. But, my lord, we think that's a natural reading or the proper reading of the rules. If there is a decision, as we say there was here, yeah, my lord, you're going to...
Sorry, I was going to actually take you back
Yeah.
to something which I'd said earlier, which I'm not sure is actually right. I was trying to take you back to the sort of origins of all this, which is the CPR Practice Direction 52 CPD 19. 19.1c says the statement should identify the issues to which the appeal should be limited and any conditions to which the appeal should be subject. It's going to be 3 pages long. There's actually no indication at all that it's envisaged that the respondent should file any evidence at all, apart from in 2b, exceptionally, the respondent it's suggested that exceptionally the respondent might file evidence in opposition to an application made by the appellant for a stay of execution or an injunction pending appeal or an extension of time for the appeal.
Yeah.
There's actually no invitation anywhere in this practice statement for the 3-page supplement identifying a condition to be accompanied or the subject of any evidence at all. It's just not real, is it, to suggest that this could be treated as an actual application by a respondent for security, for example. because there's just no facility, it's just not contemplated by this paragraph that the respondent should be able to put in the sort of materials which would be necessary.
Well, look how much material we've got.
Yeah.
3 bundles. I mean, you know.
My lords, can I make 2 points there? The first is, and this is not clear, and so I understand that it may well be rejected for that reason. We first say that there is actually nothing also stopping them from putting more evidence. But I understand that when you read the rules, that's not clear. And what we say, and what we submit, my lord, is that even in that 3-page brief statement, if you give enough information, there's a reason for that provision there saying that identify what conditions you'd like, and then the judge has a decision to make. He or she will either say, well, actually, I'd like to hear more. I am worried. You've mentioned the Luxembourg proceedings. Can you tell me a bit more about that? Or he or she will look at it and then make a decision. We cannot deny that that is, if they say, and just say, Lord Justice, you may say that Lord Justice Mills should have made it clearer in the PTA order, but just say if he did say in the PTA order, by the way, I saw you had requested conditions, I reject them. The question then is, what happens then? What is the status of that decision made on just a brief statement, if that's the rule, and that's not enough information in your eyes, or evidence in your eyes? We say that that decision, albeit not having the full force of finality, because it wasn't subject to a full application, the next step has to be, well, you go back to the judge and say, well, actually, we don't think you've properly considered this, because here is all sorts of evidence that we think you need to consider.
Well, you say, presumably, that there may be many cases, more modest cases, where a respondent may want to say, how about attaching a condition that they pay £50 in costs as the price of the appeal, and it would be obvious if the judge said no condition that the route of challenging that would be reconsideration.
Yes.
And you say it's only because it's just a big case that we're getting tied up in evidence and knots.
But my lord, what I also want to show you, because maybe hard cases don't make good law, but in this case, we say, when you look at the correspondence, if the Luxembourg proceedings are what potentially can move the needle, we say they don't. But if that's what's going to potentially move the needle, it doesn't really take more than 2 sentences to say, Lord Justice Mells, we have been injuncted in these proceedings abroad. They've stopped.
But leaving the Luxembourg, I mean, Luxembourg proceedings might be relevant to a reconsideration based on new evidence.
Yes.
But at the moment, I understand, you're dealing with the question of what is the normal routine procedure under these rules.
Yes.
And you are submitting that the normal routine procedure is if you intimate that you want a condition and the condition is not granted, you have to ask for reconsideration, because that would work in a million cases, even if in this case, where a load of evidence is going to be necessary, it might be more cumbersome than the better route to apply for a condition and get it set out in a proper application with a proper response and proper evidence. But you say the proper construction of these rules is anyway, good or ill, that's how it should be construed.
And my lords, you may decide for ill, but that is how we read the rules, that the next step here, however you want to characterize what was said in the brief statement, is we have a decision, what do we do with that decision? And we say the route should have been 5224, and you can submit your full evidence under that route.
The difficulty is, as I think we've touched on, 5218 contemplates the only situation in which you can't make an application for the court to impose conditions after permission has been granted is where you've participated in a hearing and you haven't raised the point.
Yes.
And that's probably because, I mean, I'd need to look at the entire history of the rules, but probably because this rule wasn't actually brought it fully up to date.
I don't think it was. It's remained as it was pre-2016. Yeah. My lord, can I point out a gap? When you look at the White Book, the White Book says 5218(1)(c) kicks in or is triggered when you have a situation where the grant of appeal, permission, the grant of appeal there were no conditions attached. So then you come afresh to 5218(1)(c) and say, can I please have conditions? But of course, there may be no conditions attached because a decision was made not to attach them. What happens there if it's in 52.24.6? And there we do need guidance, and we say that if you've made a request or whatever word you want to use in the brief statement, and a decision has been made, and you've gone to 52.24.6 and sought reconsideration, we would say it'd be absurd to then say, right, you can also now go to 52.18 1C, because there are no conditions attached to the commission.
Right. At the risk of flogging this horse, is it your case, as I understand it, that somebody who complies with the practice statement, paragraph 19C, 1C, and identifies a condition to which should attach to appeal, that because there's a chance the court will actually decide that question, you say it's a request, it could be decided, that the respondent must put in at that stage and serve any evidence that it wishes to rely upon in support of that application?
My lord, we say nothing stops that, yes.
Okay, well, you say
but
nothing...
even if I'm wrong on that...
wait a
Sorry,
minute.
yes. Sorry.
You say nothing stops that.
Yeah.
It's not one of the things that's mentioned that should happen.
My lord, I agree.
And what about paragraph 19.3? Unless the court directs otherwise, a respondent need take no further steps when served with an appellant's notice.
Yes.
I mean, so it's not mentioned, and you're told unless the court directs otherwise, you take no further steps. So on what basis do you say that it actually is an obligation upon a respondent to put their evidence in?
My lord, but we don't even need that provision. Naturally, if you put in a brief statement, you could say, I'm not going to specify what condition I want. I will hear what you have to say on the permission application, and then I will decide whether I want conditions. It's always a choice.
But your point is that what was said in that 3-page document by the respondents in this case was a request, was an application, akin to an application, call it request, call it what you will.
Yes.
And at that stage, they should have put their evidence in.
Yes, and even if they didn't, my lord, they could have specified enough such that a judge would look at it and say, I would like to hear more, because that is one of the discretions he has. I mean, when I showed you their letter, they specifically say we essentially have two routes. One, what we are saying in the brief statement, and also, the word also, we can also wait and apply after we hear about the permission.
Well, you agree with that, but you say if you identify the conditions and the judge deals with it, then you have to ask for reconsideration.
That is really the
I
difference.
think we've got the dichotomy. And I think that there is one clear point as to whether the rules really do allow for the situation we're now in, where everything is dealt with on paper.
Yes.
Whether inter partes hearings are envisaged as being on paper as well. But we'll have to decide what we say about that.
Yes.
But your submission is, if it's identified, and if it's dealt with, the route is reconsideration, and it's evidence on reconsideration if necessary.
Yes, my lord.
Okay, well, I think we've got that.
Yes.
Okay.
My lord.
And you said there's nothing to stop somebody putting in evidence on reconsideration that they didn't put in front of the judge first time round.
Yes. My lord,
completely free.
Well, no, my lord, can I please elaborate on that? So, if, for example, let's just take this example, and if you'll excuse me saying the mucular exit ground was used in the brief statement as a reason supporting the conditions in the brief statement. You can, for reconsideration, say to the judge, well, I think there are a number of other arguments and evidence you did not consider in support of that ground. What we say you can't do in a reconsideration is to say, oh, by the way, even though we could have mentioned the Luxembourg proceedings because we knew about them, we're now going to mention them in this reconsideration application. We think the Henderson rule applies because of finality.
Well, that's the difficulty I'm having with all this, because they had written a letter, and you've shown us the letter, in which they said, in effect, we can't put in a whole load of arguments and evidence at this stage. Although, I paraphrase, we recognise that we may need to make an application which is supported by arguments and evidence, and leave it really up to the judge. I mean, it so happens, we know, because Lord Justice Mells has told us, that he wouldn't have imposed the conditions, but he didn't deal with it.
Yeah. But my lord, isn't there?
Speaking for myself, if I'd been dealing with the permission to appeal and I'd seen the letter of the 7th of September, I might very well have said, well, actually, before I consider whether or not to impose the condition you're asking for, I want to see a bit more flesh on the bones. But
My lord, and that should be how the system...
We wouldn't be in the mess we're in now.
But potentially, my lord, because, my lord, once you say that in a brief statement you can put some information in about a condition you're requesting, or whatever word you want to use, there's a purpose for that. It's not just there, it's there for the judge to say, well, actually, I'd like to hear more. And if the reason you put in is Mikula and Ixit, which is really a very legal reason, which is saying, in Mikula, the court gave security as a next best thing to enforcement, the judge obviously made a decision. We say when it comes to reconsideration, you can't then put in 5 or 6 other grounds, not arguments, grounds, which you could have put in the brief statement, because all you needed to say were 2 sentences, my lords, that look, there's a Luxembourg proceeding, they have injuncted us, please help. I'm pretty sure that if they'd put that sentence in and they knew about them, Lord Justice Mells would have done exactly what you just said.
But you make 2 points.
Yeah.
Irrespective of the evidential point.
Yes.
You say the right route is reconsideration.
Yes.
Even if you're wrong about the evidence, even if you can put in whatever evidence you want at the reconsideration stage,
Yes.
that doesn't, you say, detract from your point that the correct route is reconsideration when the point has been decided by the PTA judge.
Yes, yes, my lord.
And, I mean, that's a freestanding point, and the evidence is a separate point.
Yes, it is.
Because you could, you accept, put in some evidence. You say there's a Henderson point on matters that are already determined.
Or that you could have raised,
You could have raised.
but you didn't raise.
Yeah.
But I was just...
It's a separate point.
It is a separate point, and I'm sorry, I'm trying to answer some of your questions.
No, well, there's 3 of us. That's the
Yeah,
always the trouble.
Lord Justice Snowden, I hope I answered your question, but I don't. If anything else, I don't want you to think I didn't. You were asking me essentially, what does reconsideration mean? And I hope I answered it by saying this: that if there's a distinction between grounds and arguments and evidence, grounds on the one hand, evidence on the other. If you say that I'm relying on ground A and there are 20 arguments in support of it, and you've only been able to put 2 in the brief statement, you can go back to reconsideration and say, here are 8 others we'd like you to consider. But we say, if you knew that there was a ground B, and the cases we pointed out were all about interference, and really the natural ground to rely on would have been the Luxembourg proceedings, and you did not put in the sentence in that brief statement, then we say you cannot rely on that in the reconsideration application.
That's a very hard submission. Because there's nothing in the rules that says you have to put any evidence in at all, or even that you have to make an identification.
Quite right, my lord, but I'm not talking about evidence here, I'm talking about ground. My lord, because if we say that the decision that Lord Justice Mells has taken to, as he said in the hearing order, not to grant conditions, has a value, even if it's on paper, and that value attracts a principle of finality, albeit, as AIC said, at a scale, and that scale and the principle of finality does include the principle of Henderson, as AIC tells us, and that must be given effect here in the sense that we think reconsideration should not include the Luxembourg proceedings.
But Henderson and Henderson, as Lord Master has just put to you, I think, Henderson and Henderson is basically a rule that says you can't raise at a subsequent date something which you could and should have raised at an earlier stage if it's not to, if to do so would be an abuse, but it's generally could and should, I think.
Yes.
The point that's made is that all that the practice direction invites somebody to do is to identify the condition.
Yes.
It doesn't say anything about identifying the grounds on which that should be made. Still less does it say anything at all. In fact, it seems to exclude the possibility by inference of any evidence being put in.
Yes.
So why is it an abuse on Henderson and Henderson grounds to at any later stage both put whatever grounds you want to forward with whatever evidence you want to? Why? How can you put Henderson forward?
My lord, can I just make 2 points on that? Okay. The Henderson point, of course, has application in different contexts, and I was going to take you to this, but hopefully it's clear from my skeleton. The Henderson point is an integral part of the principle of finality. Let me just park that for a second. As to your point, my lord, we think it's a fair construction of the requirements, or let's not call them requirements, of what is said about a brief statement, is that if you want a condition attached, we submit that that must mean that not only do you say we would like all the money to be paid in, but you need to give some sort of support for that. It would be odd just to have a freestanding statement saying, can we just have 120 million? And in fact, the respondents, when they put their brief statement in, said, we'd like 120 million, and the reason for that is the Mikula and Ixid reason. They did not say, and as I'm going to show you, they knew and they had a chance, my lord, because even after the brief statement, there was a series of correspondence in which we put forward cases saying, where's the interference? And they could have said, actually, there is interference. Here are the Luxembourg proceedings. But instead, they said, no, we stick to the Mikula Ixid reason. And if the decision of Lord Justice Mells attracts finality, which we say it does, albeit on a varying level, because it's not fully argued, there's no full hearing, we say that the Henderson principle applies to that. Although Spain's success on this application doesn't hinge on proving that bit to you, but,
it would follow, wouldn't it, that any well-advised respondent, aware of the risk of a Henderson B point being taken in whatever guise at subsequently, would say we're obliged, when we identify in our practice direction 3-page statement, in fact, we've got to make it more than 3 pages, or we've basically got to put a witness statement in with all our evidence in support and arguing the point, which is not what witness statements are supposed to do.
Yes,
so, you know, in order to avoid the Henderson being caught in the Henderson trap at any later stage in relation to any of our arguments, we've got to put it all in.
Or you can,
for which there is no warrant in the rule.
Well, or my lord, you can say that the applicant, will not mention conditions in the brief statement. I'll wait to see what the decision is on permission to appeal, and then I can go to 5218(1)(c). But if you're going to say, can I have a condition, a fair reading, my lord, and I would have thought the judge would want this, he would ask, or she would ask, well, what's your reason for this condition? At least give me a brief reason, if you don't accept it.
If you're right,
yes.
The invitation in the practice direction, doubtless well-intentioned, is a major bear trap for the unwary.
My lord, can I put it to you like this, coming at it from the other end? Anyone who says, we submit, that I would like a condition and here's a reason for it, we think that it is a fair interpretation to say that if a decision is then made on that, that decision has a status. And that has 2 consequences. One is, you're going to ask that decision to be reconsidered, some form of principle of finality applies, and then go to the reconsideration rule. Yeah.
Don't we have to, I mean, surely we have to look at the totality of what was before the court at the time of the permission to appeal application, which was not only the PD's 52C19 statement, which referred to imposition of conditions, but also the correspondence that followed it, including the letter of the 7th of September, and that letter referred in terms to Lord Justice Dyson's judgment in Day's Medical, which I've just looked at. Yeah. And that was a case in which the court had adjourned the application for imposition of conditions, and that's what he was dealing with. So what they were referring to here, as I now take your point about the use of the word also, which might be thought to be slightly odd in the circumstances, but what they're really saying is, well, if you don't deal with it now, then we would invite you to allow us to put in evidence so we can deal with it at a later stage, which is what the rules contemplate in 5218. It's got nothing to do with Henderson and finality of litigation at all. I mean, on the basis of that letter, I don't see how you could say it was a Henderson and Henderson.
My lord,
anyway,
my lord, the finality comes because I suppose the question for the court is, what is the status? If you accept that Lord Justice Mells made a decision declining conditions, what is the status of that decision?
Yeah.
If you believe that that decision attracts finality, the next question is, does it attract it to the full force? AIC says, and
well, if you made that, it might be said,
yeah.
If he made that decision, he shouldn't have made it without allowing the claimants to have the opportunity to put in the material they wanted to put in to support their case that conditions should be imposed, as per the correspondence.
And my lord, your lordships may come to that view, and then that would have to be guidance. But can I just say this, that when you have...
The judge wasn't shown the correspondence.
My lord, this correspondence was sent to him.
He must have seen it, because I don't think he granted permission
He saw the correspondence about the condition.
Yes,
I think he must
yes.
have done the
Yeah,
same.
Okay.
the condition the
Which
condition
I think
Which
request.
said-
permission was granted in October. wasn't
Yes,
it?
quite right, my
Where
lord.
they said they
Yeah.
wanted to,
Yeah, and in a s-
where they said they wanted to file evidence.
yeah, and they said that if there's any further information that the court may require, and we're not due to file evidence, but they also, our letter, where we, my lord, in more than the brief paragraph that the respondents put in, set out the case law, nothing stopping our friends opposite to do that. But my lord, there is a risk when you have a paper application that a judge may say, I've got enough here and I'm going to make a decision, or I need more. I think it may be unfair, if I may say so, to say he should have called for more evidence, but that is really a
What
matter.
I'm worried about is applying these rules to every case and not just to this kind of case. And it seems to me that we need to happen upon a construction that works for everybody.
Right.
And the problem with requiring PTA judges to call for evidence or to read a load of correspondence which explains the 3-page statement is unrealistic.
Quite right.
It's just not going to happen.
Right.
And so we need to, I mean, for my part, the most important question is your continued caveat, which is if Lord Justice Mayles made a decision on this point. Because I have to tell you that currently I'm concerned he did not. Because it's all very well for him to say, I thought about it and I did. Well, you know, one might be tempted to say he would say that, but even if you're not cruel and don't say that,
Yes.
the parties have to know, reading the order, what has been decided. And as my lord pointed out at the beginning, it starts by saying, I am deciding permission to appeal,
Right.
upon hearing the petition to appeal, or whatever it is. So if he did not decide it, then do you accept, and this is if he did not decide it as a matter of law,
Yeah.
so he knew that they had identified they wanted conditions, but did not decide it, do you say as a matter of law they still have to go down the reconsideration route?
Yes, my lord. But I also accept that you may take the view that 5218
Well, it
wants
can't be a reconsideration, can it? Because the court, on my lord's hypothesis,
No.
the court hasn't dealt with that application. It's dealt with the application for permission to appeal, hasn't dealt with the imposition of conditions, and therefore the right rule is 5218.
My lord, can I just make a few points? The first is that in Niall and Crescent last year, this very situation occurred. And I can take you to the case, it's a first instance decision of Mr. Justice Butcher, where an application was never made for conditions. He then handed down in draft his decision granting permission. Crescent, and we were on that side, then said, can you please impose conditions? He said, I can't because you're asking me to reconsider, and that attracts a principle of finality. In that case, there was no first application because his view was that if I've given unconditional permission to
Well,
appeal...
we need to look at it, not just...
Yes,
tell us
sorry,
about
I'll take you there, my lord. Yes.
And bear in mind, Mr. Justice Butcher may be wrong.
Yeah, no, of course, my lord, and that's why I said to the
It's a
extent you...
different
Yeah,
It's a slightly different regime as well.
Yeah.
my lord, I can take you to it. It's in Bundle Authority A1, tab 25, page 262 in paper and 266 electronically.
But don't assume we knew as much as about the case as you do. Since I see you were in it.
Yes, my lord.
Yeah. Can we just look at that then?
My lord, I don't know if you have the decision now.
Which
I'm going to take you to the page, but just so you have it in front of you, it's tab 25 of the First Authorities bundle, and the case is Niall and Crescent. And it's page 262 in paper, 266 electronically.
268 electronically.
Okay. It's not always 4 then.
Not always for.
Oh, apologies.
Yeah, all right.
4 in the hearing, but I think it's something different. It's 6 in the authorities, just for good measure.
Okay, so
I think it becomes 8 later.
this is Crescent Petroleum now. Okay.
My lord, it's Crescent Petroleum Niall. Ultimately, the appeal for which permission was granted was dismissed last year by the Court of Appeal in the summer. But the point here, and what this case was about, was about the consequentials hearing. The case arose out of permission to appeal granted by Mr. Justice Butcher to Niall.
Yeah.
At the time he granted permission, Crescent had not asked for such leave to be made on a conditional basis. The first time Crescent asked for conditions to be imposed was after the draft judgment granting permission was circulated for comments, but before the order memorialising the decision was sealed. NEOC's position was that it was too late to entertain Crescent's application because the judge had already granted unconditional permission to appeal, and that the only option left for Crescent was to ask the Court of Appeal to impose conditions under CPR 5218 1C. Crescent, in response, maintained it was not too late, as the order granting permission has not been made final, and so the judge could impose conditions because it hadn't been sealed. Now, the judge pointed out that asking him to reconsider the decision on conditions implicated the dead weight of finality principle in the AIC case, which in turn meant that the starting point was against reconsidering the court's decision on conditions. Crescent sought to argue that it was not asking the court to reconsider its decision on conditions because there was no initial application for conditions, the point your lordships made to me. Mr. Justice Butcher disagreed, and what he says can be found at paragraph 26.
Well, that was ultimately accepted by Mr. Dewan, who was leading on you on that occasion, I think, as I read that paragraph anyway.
Yes, my lord, but
It was
also
accepted that it was a reconsideration case.
But there was no initial application. But I think Mr. Justice Butcher also did not believe there was a reconsideration, because as he says, Crescent contended that it was not seeking a reconsideration, but I do not consider that is correct or to be consistent with the passage in Golra, which I've set out.
Yeah.
The ruling was for unconditional permission to appeal. Reconsideration of unconditional permission for appeal is what is being sought.
Yeah.
And you accepted that?
Yeah, and then that
We
was
did, but
accepted.
my lord, we did. But
Not
what,
the strongest authority.
well, my lord, but it's also clear that Mr. Justice Butcher saw that. But again, as you say, you're free to depart from that, and I can see why, as a matter of language, you may say that.
And it may be a different situation where you've had an argument at a hearing which results in a lengthy judgment, so lengthy that it had to be distributed in draft for the parties to look at on PTA, no doubt.
But not on conditions, my lord, because we didn't make
No,
it.
not on conditions, but it was obviously, I mean, that would be a classic application of 1C, where you would say, well, you didn't raise the request for the conditions at the hearing, and therefore you can't do it now. But in our situation, it's really quite different. Anyway.
Yeah.
My lord, what I was trying to address was that
It's a great case, anyway.
there is. It's not necessarily the case that just because you didn't make an application, the subsequent application to change unconditional to conditional necessarily is not reconsideration. There's too many knots in that. But and this is an example. But as you say, my lord, it was a fully argued PTA. Although, as I say, there was no application for conditions initially.
Okay, I think we may be going slightly round in circles.
Yeah.
Are there any other authorities on your first?
My lord, no. My lord, there aren't any. That was really the main one as an example. My lord, I was then going to explain if 5218 1C is the right provision, why there is a preliminary objection there too, based on essentially the Henderson principle. And what I wanted to show you here, when you go through the correspondence, that the respondents very deliberately did not mention the Luxembourg proceedings when they could have, and they should not be allowed to deploy them for this application. My lord, if you're very clear on that already, or not very clear, but you are not open to listening to that, submission, because you feel Henderson isn't the relevant
We
principle.
are going to listen to all your submissions.
Okay, thank you.
And we're not going to give you any indication of what we think about any of them.
Okay, my lord.
And it should be obvious by now that we may not all think the same, for
No,
all I know.
my lord.
Right.
My lord, I'm obliged. My lord, so really the point is this, that if you're not with Spain on the first preliminary objection, and you say that actually the proper provision was relied upon, which is CPR 5218(c), then we say that in order to consider an application under that provision, there's a certain hurdle that one must pass. And that is the hurdle that was mentioned in the Court of Appeal decision of Bell Electric and Awico. And you can find that in the second bundle, second authorities bundle, tab 37, page 584 or 588. That's authorities bundle 2, tab 37, page 584.
Yeah.
584 you want to get to.
Well, 584 on paper, my lord, maybe 588 or
Tab
5,
37.
yeah, tab 37.
And where in
And
the
it's
judgment?
paragraph 19 that I wanted you to look at, if you have the judgment at least. And it's the last few sentences of that paragraph, which are on the internal page, page 584. Right, sorry. What,
Got it, yeah.
yeah.
Sorry, where do you want us to read from?
My lords, it's the internal, I don't know how you have it.
Well, I've got
Well,
paragraph 19 of the
yes,
judgment in Bell.
And it's really the end of it where it says, however, the power in
Got it.
5291C. You got
Yeah.
that?
Yep.
It's the last few sentences. However, the power in 5291C is one which, in appropriate circumstances, properly be relied on, where the condition sought to be imposed does not involve consideration of the merits of the appeal. My lord, I'd like you to keep that in mind, because one of the grounds relied on for compelling reasons is the merits point, and I'll come back to that. But what I want to focus on now is that it's based upon some aspect of the conduct of the appellant or some other circumstances which either had not occurred or was at any rate not available to be advanced by the respondents at the time of the grant of permission. And my lord, our headline point there is that at the time that permission was granted, the Luxembourg proceedings were known about. But, and I took you to the hearing order of Lord Justice Mails, the respondents say, well, they don't deny that they knew about it, but that the brief statement did not give them enough room to mention it, and therefore they should be excused from the fact that they did not mention the Luxembourg proceedings at the time of permission.
Presumably this was an oral hearing that had been granted permission.
I
Where
think it
both
was.
sides attended.
Yes, I think it was, my lord, yes.
Yeah.
And you're saying a different principle applies. But
Well, I'm saying that it's problematic, isn't it? I mean, that might be the case
Yeah.
in exactly the same way as it might be the case with Mr. Justice Butcher. But is it the case in a situation where there is no oral hearing, where there has been no full consideration of the point, that you are prevented from relying on certain things, and if so, what? It does seem a bit harsh. I mean, what it seems to me is it's a happenstance caused by the change of the rules
Right.
without full consideration of what the consequences are of not having hearings in every case.
my lord, that may be the case, and certainly I think we can all accept when the rule was changed, or when the rules were changed, that there must have been some element that there would be harshness, but it's at the
and
price
also
of
that
efficiency.
they may mean, I mean, do you accept this?
Yeah.
That the rule which meant one thing
Yeah.
in the context of oral hearings
Yeah.
may mean something else in the context of a world where there is no oral hearing.
My lord, in principle, of course, an oral hearing gives you a fuller chance, and perhaps,
Well,
not
that's
perhaps
not
is
an
fair.
answer to my question.
But I'm about to answer your question.
Yeah.
But my lord, when you look at the 20th,
It was
Okay.
it was a case. Bell was a case where Lord Justice Longmore granted permission on paper. That's
Yes.
paragraph.
sorry, I apologise.
Paragraph 3.
Right.
My lord, but just to answer your question, in principle, in theory, absolutely an oral hearing it will seem to be fair and allows you to pursue more arguments. But my lord, when a decision has been made that for efficiency's sake, and because of how busy the court is, that you will not allow a default oral hearing and that things will be decided on paper, then we say there is already a policy signal there that there will be harshness sometimes, but that is a price to pay. Now, in this case, what I want to show you is that that harshness does not apply, because actually it did not take, as I will show you, more than one or two sentences to say, we are worried about the Luxembourg proceedings, please can you impose condition? And then I'm pretty sure, like Lord Justice Mells did subsequently, he would have said, can you tell me more?
Yeah. I mean, it's a big thing to impose on judges hearing PTA applications. I mean, there are lots of cases where people say we'd like to be paid first, or we'd like the stay lifted, or we'd like a condition that you do this or that, pay the costs.
No.
So judges have to call in the thing and ask for evidence in every case, surely not.
Well, no, my lord, but that's, my lord, that it's incumbent on you to at least put your principal reason down. If you're not very deliberately, just, my lord, remember, the respondents didn't just have a chance to say something in the brief statement. There was a subsequent correspondence where we, Spain, said, look at all these cases where interference is what triggers it. And they came back and said, no, we're going to rely on Mikula. They could have said one sentence. It doesn't take 3 pages. There's an anti-suit injunction in Luxembourg. Please do something. And in that situation, Lord Justice Mells, as he said, could have said, can I hear more, please?
I have to say, speaking for myself, the idea that in addition to the neat 3-page circumscribed document, the idea is that the court has a process which involves the parties supplementing that by exchanges in correspondence, which are supposed to find their way to the judge before he makes his decision. They may or may not. Just on the happenstance, seems to cut right across what is plainly designed to be a very short, pithy response, which identifies an issue and the judge can then deal with it. But that's the idea that the whole process should be capable of being conducted in the course of solicitor correspondence, which is put before the judge, seems to not, with respect, to be the way to design the rules.
My lord, even if we just take that as a starting point, that everything should be done in 3 pages, what we would submit is that in those 3 pages, it is not helpful just to say, I want 120 million. You have to say, like the respondents did, here is the high-level reason why. And then how it's supposed to work is then at that stage, the judge can say, now I would like to hear more. But what if the respondents deliberately did not mention a fact they knew and only focused on one reason, and the judge then says, based on that reason, I decline to give you conditions? The question then is, well, what does that mean?
Yes.
Does that decision have any status?
I mean, I think we've got.
Yeah, sorry. I'm just.
I think it's a difficult question.
Yeah.
Which is.
My lord, if it's helpful,
It always amazes me. It may be why you've got the tribunal you've got.
Yeah, I did wonder.
We've got the difficult question.
Yeah.
And we have to move on because we only have.
Absolutely,
a day
my lords.
allocated to this and you've got other points.
Exactly, my lord. Can I just say this? That what I was going to do next, and you have the point, is to show you that even after the brief statement, there were opportunities, both in the brief statement and afterwards, to say Luxembourg proceeding, Luxembourg, 1 or 2 sentences, and it wasn't done. And that's really the crux of our matter, our submission.
When did they first say Luxembourg?
In their second application, in the witness statement.
In the witness statement.
Yes, and that's why Lord Justice Mells, as I showed you in the hearing order, said, I did not know about the Luxembourg proceedings, paraphrase him, although they were known at the time of the grant of permission to appeal, but it may be right that the respondents did not have essentially the space to put forward the case on the Luxembourg proceedings. And what I wanted to show you was that they could have, but I think you have the point.
I think we've got the point.
Yeah. My lords, I'm being told that we should give the transcriber a break.
I'm afraid we don't do that in this court. Poor old transcriber will have to work through or stop transcribing.
My lord, I was then going to move on to the merits.
Yes.
My lord, based on the questions you've asked me, I don't feel that I need to explain to your lordships the principle of finality arising out of AIC. but I wonder if it's helpful, and here I am asking for an indication given the time. It's a question that Lord Justice Snowden was beginning to ask, which is, and I suppose there's an essence of which you're all asking, what is the status of a decision that may be, as we say, subject to a reconsideration under 52.24.6? Does that attract the principle of finality? Because, of course, the respondents say that whatever Lord Justice Mel said, you can ignore, and you can assess afresh and de novo their application for conditions under 52.18.1c. We say you can't, that you have to bear in mind that there is a decision there already saying that conditions are not justified.
Well, what decision?
The decision of Lord Justice Mel's that...
No, it's not. It doesn't mention it. It doesn't deal with it at all.
Well, my lord, we say...
He may say, as it were, I mean, it may be helpful to be told something he thought about and didn't impose a condition, but the reality is, on the face of the court record, the application simply wasn't dealt with.
Okay. My lord, if your lordships take the view that there was no application...
I mean, obviously, if he'd said, I find the condition asked for shouldn't be imposed, well then it would have to be dealt with by way of reconsideration, and all the points you make about reconsideration would be entirely justified. But he just didn't deal with it. Okay.
My lord, can I just say this then, and I'm in your hands as to how many of these submissions. If your lordships take the view, Ms. Miller, that there is no decision... No, I appreciate that. I'm just setting out the cascade of arguments. If your lordships take the view that there is no decision here, then obviously the principle of finality doesn't kick in, and this is a whole new application. If it is a decision, and we say, when we, my lord, as a state coming to this court with its lawyers, reads that hearing order, and Lord Justice Mel says, I did consider it, and I think a fair reading of my decision on permission is that it was rejected.
He doesn't say that.
My lord,
he doesn't say a fair reading of what I said is.
Well, my lord, if you read it, he says it to be construed. We can go through it.
Anyway, even if he does say that,
yes,
it doesn't matter,
It's for him.
because the important thing is to work out from the face of the order and the documents that were before him what he decided.
Right.
Right. Now, I think we've dealt with the submissions on that. Now,
Yes, we have.
You're now coming to the question of finality,
Yes.
which you accept is only relevant if the judge made a decision.
Quite right.
Now, you must tell us what submissions you want to make about finality on that premise. We are not going to decide that for you. If you wish simply to rely on your written argument, simply highlight where it is and move on. If you wish to deal with it orally, it's up to you to do so, but I think to be fair to both sides, you're going to have to finish your oral submissions by lunchtime.
Yes, my lord.
So,
and I will certainly do that. My lord, what I would propose to do is that in terms of the core principles of finality that a decision of a court attracts, those are in the skeleton. And I don't need to go through them.
Yeah.
Your lordships are aware of it. What perhaps is less considered is the point that's also made in AIC, and it's directly relevant to what the respondents say, that there is a varying standard of finality because there are different sorts of decisions. And I just wanted to pick that up, if I may, my lord, in AIC. First, can I just ask you to turn to AIC itself?
Yeah.
I mean, AIC, I'm sure, is a great decision, but there's House of Lords authority.
Yes, Supreme Court, my lord. Yes.
Yeah. Okay. Let's look at AIC.
Where is
It's
it?
an A1, if you're looking at the paper bundle, tab 24.
Yeah. Okay.
Page.
Oh, sorry, AIC.
AIC.
I thought you were talking about the National Iranian Oil Company.
No, my
Sorry.
lord. Which I do think is a great case, but I accept that.
It's the first instance.
Yeah, but
You've got
yeah.
Supreme Court authority, AIC.
yes, I do.
Recent Supreme Court.
Recent Supreme Court authority, my lord.
Comforts me greatly.
Yeah.
Which is what page? What tab?
It's tab 24, hearing bundle. Page 242 in paper, and
Yeah.
I hope 246 electronic.
Yeah.
248.
248. I stand corrected.
Yeah.
My lords, as I said, we already have put our. I could walk you through what they say about principle of finality, but as I said, you know
Just
that.
give us the paragraphs.
The paragraphs are, well actually my lord, you can look at it because there's only two paragraphs. It's paragraph 29.
This is the varying scale.
No, the varying, that was the varying scale paragraph is,
Thirty-five.
35.
It's the end of 34, beginning of 35.
Yeah,
35.
35.
Oh gosh.
If you give me a signal, then I want to show you another paragraph.
Yes.
The other paragraph, my lord, I wanted to show you is that in this case, the order itself was not subject to a full hearing or a full opposition, but the Supreme Court said that that order, which was a subject of the reconsider an application, was also subject to finality, and you'll see that at paragraph 59.
Sorry, can we just make the point? This case is dealing with the question about when a court should reconsider a decision before an order is sealed, isn't it?
It's more than that, my lord, and that's what I was going to take you to, but if you actually look at, that is the formal question that was before it, but it's a much more wide-ranging decision, not just about whether you can, whether a judge can change their decision in between issuing a draft judgment and before it's sealed, but also more broadly the reconsideration of a decision. And you see that, my lord. In paragraph 30. And it's very clear when you read the judgment, my lord, it's not just about that very formal question, what can happen between draft to seal. It's also, the foregoing review of the authorities shows, this is paragraph 30, that the task of a judge faced with an application to reconsider a judgment and or order
Before the order has been sealed.
Yeah, but
Is to do justice.
yes, my lord, but when you
It is
read,
about.
yes, my lord, but it is more than just before it has been sealed.
Okay.
Yeah.
Anyway, that's what they're focusing on.
It's,
Anyway, if it's just to do justice in accordance with the relevant overriding objective, that gives us a very free hand.
yeah. And my
In
lord,
that case, I mean, I was in the Court of Appeal in that case, so that it's a very different sort of case, isn't it? As my lord said, it was all to do with. We're not in that territory at all, are we?
well, my lord, we're in the territory of we say, an order that's been sealed, and and the respondents are asking you to reconsider it. It's a much more extreme situation, and the Supreme Court read fairly, or when you read it, you'll see that it is not just focusing on that; it is generally about the principle.
Where
of
do they deal with what the position would be if the order had been sealed? Or do they deal with that?
They do, my lord, but my lord, if you look at paragraph 35, at the end, the last sentence, after the order is sealed, the finality principle applies in a more absolute way.
So, which paragraph?
That's paragraph 35.
Yeah, got that.
Yeah.
Okay.
My lord, and all I wanted to show you then was paragraph 59, sorry, because that discusses the order that was in play in that case. And it's a third sentence. As to the first, we have already concluded that the enforcement order was a final judgment to which, although there had not been a full trial or even serious opposition, the finality principle applies with almost full force. I'm not saying that what happened in relation to the enforcement order is the same as we say if you consider it a decision here, but it's certainly what it illustrates is that you don't have to have a full hearing and a full opposition in order for a decision to be one to which the principle of finality applies.
So it's the third sentence of
Yes.
59.
Yes, it is, my lord.
Sorry, I got waylaid into looking at them describing Denton.
My lord, can I take you to one more decision, because it may be that your lordships, in their judgments, have to address these issues, maybe for guidance purposes. So at least, if I may, just take you to it. And it's a recent decision of Lord Justice Nugee, if I'm saying his name properly.
Yeah, in where?
In Williams and Williams, and it's tab 28, Authorities Bundle 2, and page 336 on paper.
Volume 3.
What's that?
Volume 3. That's right. Apologies. No, you're right.
Volumes.
340.
It's page 336 on paper and 340 or 342. Yes. I'll take you to the relevant paragraph in a moment. Can I just quickly set out the background of this decision? My lord, the first, again, we've addressed this decision at paragraph 21 of our skeleton.
He prefaces the judgment by saying it should be obvious to everyone that it's not being considered at great length.
Yeah, yes. My lord, of course, if you take the view that that means what he says it does not carry weight, then I'm
Well, no,
that's
let's
useful.
look at it.
But can I just at least, because I think it makes sense, of course. The first decision on paper in this case, granting permission. Sorry, my lord, just quickly. My lord, in this case, the appellant tried to argue that Lord Justice Lewison's decision on paper granting permission on limited grounds was not a judicial decision or not fully considered, such that it could be revisited and the scope of leave expanded at the oral hearing before the full court. And Nugee, or Justice Nugee, rejected the notion that a decision by a single judge on paper was something less than a properly considered judicial decision.
I don't think we need authority for that.
No, okay. Which could be ignored. The relevant passage, my lord, if you want it, is at paragraph 21.
Right.
It is true that in many cases, decisions made on paper by courts are subject to the right by the person affected to have them reviewed, often at an oral hearing. But that does not mean that the decision on paper was not a judicial decision, and to my mind, a decision made by a judge exercising judicial power reached on paper and stamped with the court seal is an order.
You said 21, but it's
24.
24, apologies, my lord.
Yes.
Yeah, okay.
My lord, in the remaining time, what I was going to do, just so you know, because there may be different the routes that one may take, if on our submission you are with us and you say that there was a decision and the principle of finality applies, then there is a balancing exercise to be done. The dead weight of finality, of course, it varies because this is not a full a decision after a full hearing, etc. And against that, you have to balance whether the facts now put before you justify displacing that dead weight of finality and motivating you or prompting you to impose conditions. Now, of course, you may say, you may decide in the end, my lords, that this is not a decision and the principle of finality doesn't apply. But even in that scenario, what I want to show you is that the test for compelling reason is not satisfied here, my lords. Whether you do it by balancing or just looking at the factors.
Now, I mean, I'm just, by all means do that, but I thought at the beginning the idea was that on compelling reason, you would let Mr. Green go first.
Yes, my lord.
And come back. Now, for my part, I think it would be helpful if you told us what you said the test was that we should be applying on compelling reason. But if it is just compelling reason, then that's fine. And the judgment of Lord Justice Christopher Clark and all that. But then to deal with the facts, it might be useful if you replied and see how Mr. Green does in making his case.
Quite right, my lord. I'm sorry you did say that, and I did not comply. Can I then just, in 1 minute, set down the 6 propositions of law we say apply in the context of...
the same
Propositions of law we like.
Lord Justice Christopher Clark's.
No, they're a bit different because they update it with more recent case law. They are, in essence, summarised in the Spain skeleton at paragraphs 40 to 43. But can I just recap them?
Shall we just have a look at that, if you don't mind us having the chance to get it up? It seems nowadays to be eccentric to refer to one's skeleton in the course of oral argument. When I was at the bar, we sort of felt we had to.
Sorry, what
It's
paragraph?
paragraphs 40 to 43.
Whilst there's a species of case,
Yes, my lord, and it's in somewhat block text because we had to fit the 25-page limit, but I was going to give it to you in easy bite-sized propositions very quickly. The first is that the granting of conditions is rare and unusual. Second,
hang on, you've got to take this a bit slowly.
Sorry,
It's
Michael.
coming out on the transcript.
apologies,
Grant of
conditions
conditions.
is rare and unusual.
Yeah.
Second proposition, they are not meant to be an alternative means to secure enforcement. Caution must be exercised. Lord Justice Flo, that is from Merchant International, but as I said, the footnotes are in the skeleton.
Merchant International.
And the first proposition about rare and unusual is Dumford Trading. That again is in the skeleton. So
Okay, have you got, I mean, if
I've
you've
got the
just
references. Shall I give you the
page-
references?
Page numbers would be
Yes.
absolutely
my
marvellous.
lord, for the first proposition, Dumford Trading, it's the first bundle of authorities, tab 12, page 112 to 113,
Paragraph 9.
and it's paragraph 9.
It's Lord Justice Christopher Clark again.
Yes.
Okay, and Merchant
This
International.
Merchant International, which is a third bundle authorities, tab 46, page 693 of the bundle, and paragraph 37D of the judgment.
Actually, Dunsford Trading is Lord Justice Clark, as in Sir Anthony Clark, as he then was.
Yes.
Christopher Clark.
And also, those are two. The third proposition is that the touchstone is taking steps out of the ordinary course, something illegitimate, with a view to frustrating enforcement.
I'll say that again. Touchstone is
The
taking-
touchstone is usually taking steps out of the ordinary course.
Yes.
We say something illegitimate with a view to frustrating enforcement. And for that proposition, my lord, we cited Sebastian Holdings, and that's a third authorities bundle, tab 43, page 659, paragraph 34. My lord, we say that the main illustration of that sort of frustration is the dissipation of assets, or another triggering factor is usually disobeying court orders for payment, none of which are true in this case, because Spain has complied with all the payment orders.
Apart from the big one.
Well, as in the order for cost, sorry, and not the judgment. Yes, my lord.
But apart from that, Mrs. Lincoln, how was the play?
Yeah, my lord, that may be okay. Well, my lord, well, can I put it to you like this, my lord, that every case in which they've spoken about disobeying court orders, they're not talking about the judgment, but cost orders and things of the like, of course. My lord, the fourth proposition is that the purpose of conditions is not to reduce any downside risk of enforcement. It is not meant to make enforcement risk-free. And the proposition the case for which we cite, there is Clewer and Higgs, which is in the third authorities bundle.
I mean, that really flows from your second heading,
Same
doesn't
point.
it?
Yeah.
It's the same point.
But it's just an illustration that the aim is not to have some sort of risk-free situation.
Yeah, but your main point, as I understand it, is that the fact somebody is exercising a ground of appeal, or seeks to exercise a ground of appeal which they have a right to do, shouldn't be the opportunity that the court takes to grant enforcement by the back door.
My lord, and if I may just add one more point, and the fact that they
Is that a fair summary of your second point?
It is, but what I had in mind was pursuing legitimate claims in the Luxembourg courts because of EU law compliance is also not to be a reason, is not an illegitimate or out of the ordinary course example of steps that a party may take.
Well, that's the facts, yeah.
That's a fact, yeah. And the reason why, my lord, I'm mentioning what you said is really, and you're right, it is subsumed within the third proposition, but I'm very specifically talking about the security that a party may have, and it may not fully satisfy the debt, is because in this case, as I mentioned at the start, there is an interim charging order. And even if you say it's not worth 120 million, there's no evidence of it.
That's the facts. You
That's
had
the facts.
6
I
points
guess.
of law
Yeah.
that I
My
wanted
lord,
to add.
the final proposition, my lord, is this.
Hang on a moment, I've lost track now.
I've only got 4.
What's
sorry.
the fifth point?
Fifth. I can't count, my lord. The fifth point, not the sixth.
Yeah.
The condition must be proportional an effective means of achieving the purpose of the conditions.
You mean proportionate?
Or proportionate, and effective means of achieving the purpose of the conditions. And that's in the recent case of Al-Sabahi, Authorities Bundle 3, tab 51, page 838 on paper 842 or 846 in electronic, and paragraph 11.
That's the decision of...
I think Lord Justice Miles, yeah, yes. Lord Justice Miles, I think that's the decision.
Al-Sabahi.
Yeah,
Paragraph?
11. Those were the legal propositions, and
So there weren't any 5, is that right?
yes, my lord, I misspoke.
Yeah.
6.
Okay.
Okay, lovely. Well, and you say we will give you liberty to come back on the facts, which will enable you to make good the points about charging orders and stuff, even if Mr. Green has said nothing about them.
Yes, quite.
Okay, so don't feel you're inhibited in reply from making good
I'm grateful.
your case as to why there should be no conditions on the facts.
Thank you, my lord.
Right, subject to that, is there anything
Unless
else
your lordship
my
has-
lords would like to ask? Mr.
No, thank you.
No, thank you. Thank you very
Thank you,
much.
my lord.
Good, Mr. Green. You're back.
Back in action. My lords, can I just make one overarching submission, which I think actually there is really no mess at all in the rules, and there's really no mess in this case, other than the 2 essential bases on which Spain seeks to invite the court not to look at the merits of the application. And both of them, with the greatest respect, are utterly without merit on the face of the rules themselves, and when judged against the overall scheme, in this case and in all cases, and in the light of the relevant authorities, which I'll show the court very briefly. Hopefully I can slim it down to only a few.
So what do you say? You say the rules are absolutely fine and we don't need to worry about it.
Well,
Not to worry our little heads.
I wouldn't put it like that, even within my little head. No, my lord, I think the short point is that clarification from this court of how they work would probably be very, very welcome.
Right.
And that's why I hope...
But you say on their true construction they already work.
Well, if you read the whole lot, they're absolutely plain,
Yeah.
and they do work.
You better tell us how.
Can I go slightly old school, as my Lord Master of the Rolls was suggesting, and refer to our skeleton argument? It's in the bundle, Bundle H. I think there should have been some freestanding wire-bound ones lodged as well.
Yeah.
I don't know if they reached the court, but it's in Bundle H electronically, and it starts effectively on page 81.
I just need paragraph numbers.
Paragraph 12. This is where I begin to deal with where we begin to deal with the rule. And there are 3 main reasons, and this is obviously on the original basis of opposition, and I'll come to the 5224 argument in a minute, but one can't actually read them separately. So in my respectful submission, one does need to look at 5218 first, and then look at 5224 and see them together. And I won't labour the points too much, but there are some quite important small points. And the first is that in relation to 5218, that is, as my Lord Justice Flo observed, that is specifically providing a procedure for an application to be made after the grant of permission. And the Court of Appeal in that sense, the rules confer on the Court of Appeal in that respect what is essentially an original jurisdiction for that purpose.
So you say 5218, even the test of compelling reason has got nothing to do with an application for permission to appeal where the conditions are sought.
Well, my lord, what the submission is simply this, that 5218 is an express provision by the court, as Lord Justice Flo observed in argument with my learned friend, for applications to be made following the grant of permission to appeal.
Yeah, but that doesn't answer my question.
Well, my lord, I may have misunderstood it. Could your lordship?
5218, let's assume,
Yes.
is an express provision for applications to be made following the grant of permission
Yes.
to appeal. 52.18(2) says the court will only exercise its powers under 1 to strike out, set aside or impose conditions or vary them where there's a compelling reason
Indeed.
for doing so. Does that provision apply to an application for permission to appeal in which the respondent asks for conditions to be imposed? In other words, can the court only impose conditions at that stage, applying this rule?
Does your lordship mean at the PTA on paper stage?
Yes.
Yes. At the PTA on paper stage, where the PTA on paper stage, one would expect the court normally to adopt a similar approach to.
Well, it
must make
if
sense.
you're right, then the CPR 52C, PD 52C, paragraph 19 statement effectively sets out your stall as to what conditions would be appropriate. But the actual application to impose the conditions is a separate creature. Is that right?
No, my lord. Well, can I just take it in stages?
Yes.
It's probably worth looking. I've gone through what the position is on page 83 of the skeleton, paragraph 20. So after the application for permission to appeal has been lodged and filed, the respondent may, and it's quite important that the respondent is not required to file this.
Yes, get that.
So if someone doesn't do so and doesn't assist this court or the single judge on paper, as encouraged to, on Malone and Friends' argument, they're in a better position than they would be otherwise.
Yeah.
Which is completely absurd, we respectfully suggest.
I think
They avoid the bear trap.
I think what the Master Rules was asking you, if I understood it, was this: assume that following the indication that's given in the 3-page document of, identification that a respondent would like conditions to be attached, the judge here deciding on paper the application for permission to appeal, or indeed at some hearing he may direct to enable him to do so, does he apply any different test than the compelling reason test as appears in 5218?
We would say it's logical that the judge at PTA applies the same test.
But I don't know whether that was the...
That was indeed the question.
My lord, I'm sorry I didn't answer that.
May I ask why?
Uh,
Since the rule doesn't say so.
Well, my lord, only because the same discretion is effectively being exercised
Just
to
we
the
sort
same
of
effect.
have a bit of a hunch and we say it's obvious.
Well, my lord, it's sort of what Lord Justice Staunton said in Solo Bone when he was.
I don't know what he said, so you would have to show me if it were relevant.
Well, that was a fairly impressionistic approach to, and this arose in a recent hearing, in fact, where Lord Justice Snowden was a member of the court, about whether on a Section 77 application under the Arbitration Act, security should be ordered. And can I just tell the court how I respectfully suggest it should work? So what happens is the respondent may serve the brief statement, but it's important to note that if one looks at the practice direction, which is in bundle A1 at page 34 or page 40 in the electronic one, it's 1A is permissive, not a requirement. But if you do, 1C says the statement should identify issues to which the appeal should be limited and any conditions to which the appeal should be subject, and refers to 52.6.2. So, my Lord, the Master Roll is absolutely right that it doesn't say there that the power can only be exercised where there's a compelling reason. And it may be that, having just said the test is the same, on reflection, well, it may be that where the court has not instinctively imposed a condition at the permission stage on the papers.
Sorry, why linguistically does 52.18.1c not apply at any stage in the appellate process?
Well, so the 52.18.1c does apply at any stage.
And so at any stage, if you're considering whether to impose a condition upon which an appeal may be brought, you can only do so for
If it's
compelling
compelling.
reason. So
Well, linguistically, I think it must be the same
right,
test.
He talks about varying conditions.
Yes,
So
it must be the
you
same
might
test.
do that quite a long way down the line.
Yes. Yeah.
But circumstances
Exactly.
change.
Circumstances
I
have
mean,
changed.
or indeed the first instance judge gives permission to appeal and
Yes.
doesn't say anything about conditions, but
Yes.
the Court of Appeal
Exactly.
might,
Yes.
on application,
Yes.
think it appropriate to do so.
Yes. I think it must be the same test.
Yeah, so I mean, just as a matter of linguistics, I don't think the rule is actually, we're all focusing on it, as it were, after an initial decision, but in fact,
Yes.
it's without, it's at any time during the process, isn't it?
Yes, there
Same test.
are some cases which suggest that it's principally directed, shall I say, to the basis upon which the appeal may be brought rather than the giving of permission per se. And that seems to me, with the greatest respect to those cases, it's right that I tell you they exist, but that seems a distinction without a difference in some sense. And on the face of it, the rule works perfectly well together with 52.6. So that
So the answer to my question originally is that I'm wrong. This rule does say that if you're imposing or varying conditions,
Yes.
you apply that test.
yes,
Right, good. Okay, let's move on.
I'm grateful. So the important thing just to note is that impose or vary in 52.18.1c includes a situation where the judge on the papers has said, well, this is plainly a case where there should be a condition imposed,
Yes,
and imposes one,
yes.
and the disappointed appellant applies to vary that. So it's important that it may be an application made by an appellant or a respondent. And just going back, if we may, to our skeleton argument on page 83 of the hearing bundle, which I think is 87 electronically, it's important to note that at the stage, as Lord Justice Snowden observed, the practice direction specifically provides in paragraph 3, 19.3, unless the court directs otherwise, a respondent need take no further steps when served with an appellant's notice prior to being notified that permission to appeal has been granted. And that reference to no further steps is a reference to no further steps other than those set out in this paragraph. And your lordships may wish to note that the letter which comes to the parties from the standard letter from the Court of Appeal, if I can just show the court how that chronology developed. It's in hearing bundle 3, and the letter acknowledging the appeal is in tab 26 at page 1125.
Tab 26.
So that's the first letter.
1129 electronic.
So 1129 electronically. And at the bottom of 1129, the bottom paragraph, it says, where an appellant seeks permission to appeal respondent is permitted and is encouraged within 14 days of service of the appellant's notice or skeleton argument, if later, to file and serve upon the appellant or any other brief statement of reasons why permission should be refused in whole or in part. See the practice direction. And there's no mention there of the provisions in relation to the requirement, if you do so, to identify any conditions or limitation thereon. If we go to page 1129, which I think is 1133 in the bundle, this is the letter to the appellant, which is copied to the respondent, and it says what the respondent should do next.
Hang on a moment. Not sure that's right.
1128 is the first page of the letter.
Got it. Thank
From
you.
the Civil Appeals Office, 1132 electronically, I think it should be.
Yeah.
Over the page.
What respondent should do next?
Exactly, which is exactly the same point, and doesn't highlight the requirement to identify the conditions or limitations on permission, but they are plainly there in the practice direction itself, so that if you do indeed lodge the brief statement, you must identify any conditions you say you should be imposed. And my learned friend took the court to...
What if you don't?
So
What if you don't?
well, my lord, I don't think you may be criticised for not having done so, but you're not precluded from making an application thereafter.
And just out of interest, if you do put it in, you're not entitled to normally get your costs of doing it.
No.
So it's not expected to be anything very substantial.
Exactly. You can't get your costs. It's limited to 3 pages. And importantly...
there's no mention of putting any evidence in support of it, and the only evidence that is mentioned is in opposition to something that the appellant is seeking to do, and you're told specifically you needn't put anything, you needn't take any other further steps unless the court directs. And you can't get your costs.
So that's it. And then...
So Mr. Justice Butcher, by analogy, is wrong.
In what respect, my lord?
Well, Mr. Justice Butcher said, if you had not, when applying for permission to appeal, in opposition mentioned you wanted conditions, and there is an unconditional permission granted, it was not open to you later to say you wanted conditions.
Well, my lord, the difference there is that was a fully argued application.
At a hearing.
At a hearing.
So 5218 3 would apply.
Exactly. It's completely different. I mean, my lord, the short point, just cutting to the chase, the short point is there's a perfectly sensible, if relatively efficient system now for assessing PTA applications, and they are confined, and the judge takes a view on permission to appeal and does not invite lengthy submissions from the parties normally, nor would that be a proportionate or sensible way to conduct that exercise normally. And in fact, although it is the case that the rule hasn't been updated since the right to seek an oral renewal application on a PTA application was abolished, and it's now a matter of discretion only. Although it hasn't been updated, it still works perfectly sensibly. The single judge looks at it on the papers, he makes a decision, and whether he imposes a condition or not, there's a perfectly sensible rule afterwards which tells you what you can do. But if you've fully argued it already, you can't. I mean, it makes total sense. There's no mess at all in our respectful submission. But the point I was going to make, if I respectfully could...
So you say that in the run of cases where there's no hearing, which is
Yes.
99.9% of cases,
Yes.
despite my encouraging judges to adjourn cases for an oral hearing where they're difficult,
Yes.
but they don't often do so.
Yes.
You say that in 99% of cases where there's no oral hearing, the identification is basically optional because there is no content, no sanction if you don't.
Yes.
You can apply at any proper stage under.
Anyway, to identify the condition.
Yeah.
It'd be strange if there was a Denton and White consequence, a relief from sanctions.
But
consequence.
let's say, let me give you another example. I'm sorry to question
right.
it, but
No, it's very helpful.
Slightly concerned. Let's say in your respondent's statement, you say the claimant, the appellant should be required to pay £100 in costs that was ordered by Mr. Snooks, Justice Snooks, on such and such a date, and they're very bad people, they haven't paid it, and they should pay it.
Yes.
We don't wish to find any more evidence about this. Please decide.
You're not
And
entitled to what? Sorry.
Just let's say we say that. They say that. And nobody says anything else, and the judge says, I've looked at the submissions of the respondent, I reject the request for an order to pay £50 in costs as a condition of this appeal.
Yes.
You say it is still open
Yes.
to the respondent to go forward because there's been no hearing, and it has to be treated de novo
Yes.
by a single judge.
Yes.
Okay. Seems a bit strange.
Well, my lord, not really, because I would respectfully, just in terms of your lordship's concern about the run of appeals generally, I would respectfully submit there's no obligation, in fact, on a judge at PTA to make any decision either way on a condition that's been identified or a limitation that's been identified. Because he may simply feel, he or she may feel that they don't have enough information to make a clear decision at that point. The point hasn't been, not only has it not been fully argued, it hasn't been argued at all. So,
But my lord's question to you was premised upon the basis that the respondent in their document said, I don't want to make a specific application, brackets, because I don't want to pay the cost, the fee.
yes,
Please, if in effect, treat
Yes.
this as an application. I don't want to put anything else in, just will you decide it on this basis?
yes,
And the judge says, okay, I'll do that. I won't require you to pay the fee. I mean, I'm charitable. I'm not a fee collector.
yes,
I'll make the decision. I'll reject.
yes,
You're saying that the respondent who asked for that very specifically on those terms in its 3-page document can just say, no, I'm going to swan up to the court and I have changed my mind now. I won't take no for an answer. I'm going to have another go.
yes. I mean, sorry. Let's take it in stages. There are 3 different points. Number one, point I haven't mentioned yet, is that 52.18.3 is not a jurisdictional bar at all. And I think had some of the earlier courts in which this has been argued been aware of that point or had that point made to them, it might have made their life a lot easier in trying to get round 52.18.3 in the cases where the court has got round it by imposing conditions or not striking it out. So what in fact 52.18.3 is a procedural bar to a party from making the application. It doesn't stop the court doing anything.
Doesn't stop what?
It doesn't stop the court making such an order at all, if the court thinks fit. It prevents an application being made by a party for such an order.
Of its own motion.
It prevents a party from making the application, but it doesn't preclude the court's jurisdiction to make such an order of its own motion or to impose it as a condition
So you
under
could,
1A.
you could issue an application saying, I know I've had a hearing, but I want you to make an order of your own motion, please. So as to
Well, no,
get
that
down
would be
to-
precluded because it's in substance what's precluded.
No, I mean, what you're
Yeah, but-
postulating is the possibility that the respondent doesn't make any application at all. The court looks at it and thinks, oh, well,
Yes.
maybe it would be a good idea to impose some conditions.
Well, because all that we haven't taken the court to the cases in which the court says, well, hold on, we must have power to regulate appeals before us, notwithstanding that rule. And the Court of Appeal has repeatedly got round 52.18.3. And if necessary, I can take the court to these couple of these cases after lunch, but repeatedly got round 52.18.3 by saying, well, what we're going to do is we're going to say we'll strike it out under 52.18.1a because that's not barred by 52.18.3 because 52.18.3 only bars 1b and 1c in that final line.
Yeah.
We'll strike it out unless you pay security in. So they make it a condition of the decision on the strikeout.
But why are there two provisions? On the basis that you answered my question, that it is open to you
Yes.
at any stage to come under 52.18, why, in my question to you, namely
Yes.
whether the respondent says, please decide this, judge, and the judge does decide it, is it not also open to the respondent to ask for a reconsideration under 52.24?
Well, no, my lord, the reason they can't do that is that because on the express words of 52.24, 52.24.6,
This is an application for permission to appeal.
it is. And and Mr. Justice Neuberger, as he then was, in the very case my learned friend originally relied on jurisdiction complaint number 1, says it's a unitary decision.
Which case?
So that's re-medical justice. And the court will find that in the bundle, in bundle 1, it's tab 13. Yeah.
This, of course, was before.
This was before.
This is Lord Neuberger.
Sorry, page
I'm so sorry.
1, 2.
So the page 129 in this bundle, which is 135 electronically, paragraph 13. So the master rolls there, Lord Neuberg was considering the fact that the decision on a condition and the decision on permission to appeal is a unitary decision for the purposes of very different facts. And the court will see on page 128, paragraph 6, there was a contested hearing. After judgment was given, there was a contested hearing of the Secretary of State's application for permission to appeal, where the argument concentrated, albeit not exclusively, on the terms on which appeal should be granted. So there'd been a full hearing here, and Lord Neuberger was, in this case, regarding the decision as unitary, so that the refusal after full argument to impose a condition or limitation on permission was part of the single decision against which an appeal was barred by Section 54 of the Access to Justice Act.
But I mean, all this is, if I may say so, really not in point because of what he says at paragraph 8. When a first instance judge grants appeal on terms, permission on terms, he's got three choices: abandon, treat the conditional permission as refusal and apply again, or to accept the terms.
Exactly.
But that's at a hearing, no doubt.
Yes, exactly. So your lordship's absolutely right. One, this was all about something that happened at a hearing.
Yeah.
But the point was that the observations that the learned friend sought to rely on in his original jurisdiction challenge about potentially 52.18 being ultra vires was based on the decision in this case.
He no longer says that.
Well, I think he no longer says that. But the short point is there's a unitary decision and which falls under 52.24.6. The decision determining application for permission to appeal includes a decision in which that is granted subject to conditions. So where a positive decision is made by the court one way or the other,
Yes.
that's absolutely clear. But also,
Then what happens? You can either seek a review.
no, you all
If it's a unitary decision,
yes,
then sub 8 of whatever it is, which says save for a permission to appeal decision, applies.
yes, exactly, sub 6. So the
Sub
point
6,
is you
so-
can't use, there is no mess. You can't use 52.24 because of 6 and it's part of a decision on PTA. And point 1. Point 2, there's an express power provided in 52.18, which Lord Neuberger observes at the bottom of 129 in medical justice, that the answer to the point Malone Friend was making is perhaps because the court has under 52.3b an original jurisdiction in relation to permission to appeal, or otherwise. But the short point is that 52.24.6 does not apply because of the exception, and 52.18 positively does apply. Indeed, that's the very purpose for it being there. And, my lord, the reason I say that a respondent who, however floridly he invites the court to make a decision in the brief statement, is still able to make a full application.
In fact, I think is this right? You essentially say, in that 3-page statement, which is optional, if a respondent says, I identify that permission ought to be subject to conditions, what the judge seeing that ought to do is just to decide the PTA, assuming that they can, and say, right, if you want conditions attached to it,
Yes.
Make an application, and then
Yes.
I'll give directions and we'll hear it.
Indeed, and indeed, it's limitations or conditions. But if the judge at PTA, I think that the key point about this is there shouldn't be a ridiculous burden on the single judge assessing PTA on the papers. There's no obligation whatsoever for the single judge on the papers conscientiously to consider and decide one way or the other in relation to a condition. It's information for the court.
Well, you say that. I mean, I think it's a bit more difficult than that because there is a whole range of possible situations. So I completely understand what you say
Yes.
in relation to a condition like this,
Yes.
where you say this is a freestanding, separate decision that should sensibly be taken under 52.18 after evidence has been filed. But that means that it's not a unitary decision. It's very definitely non-unitary because it is separate, it is completely irrespective and without regard to the PTA itself. And the PTA is a nice point of law which has nothing to do with
Yes.
this. And this is all about your bad behaviour or somebody else's bad behaviour, it doesn't matter.
Yes.
It's quite otherwise if it is unitary in a genuine sense. So they say you shouldn't give this person permission to appeal because they've been so bad and they haven't paid the costs. But if you're going to, you must order them to pay the costs. And there's a compelling reason you should.
Yes.
And the judge decides, I'm going to give permission and order them to pay the costs.
Yeah.
Now, that is a genuine condition. It is a unitary decision on one analysis.
Yes.
And my question is, I suppose, why that is not in any sense final on your analysis.
Well, only because it's essentially ex parte, and it not only has it's final in the sense that unless an application is brought as provided for by the rules, it's final. It's a final order in that sense. There's no problem with that. But it is an order that has been made without, not only without full argument, without any argument.
Yeah, but that's the same with the PTA itself.
Yes, but the rules make specific provision for the PTA for a reason, and the rules
Make different provisions.
yes.
Well, what the rule? Yeah, I mean, I see the force of your point in this sense that if you look at it, I mean, in terms of the PTA, you've got the appellant's notice, skeleton argument, plus the respondent's statement.
Exactly.
If the respondent says, well, you should, you know, I'm flagging up that I think there should be a condition that they pay the full amount of the
Yes.
judgment debt into court as a condition of being allowed permission to appeal. There isn't anything in the rules or in the practice direction that provides for the appellant to have some opportunity to come back on
Oh,
that
but precisely, my lord. That's what I was actually going to show the court.
and engage in the sort of ping pong that
Yes.
one wants to avoid.
Well, and the reason is, in the letter that we looked at earlier, at 1205 in the bundle,
Yeah.
we looked at the second page where we rigorously stuck to what was required
Yeah.
at 1206, which is 1210 in the electronic,
Yeah.
and said, look, what's required by the brief statement is to identify, underlined, etc., and make the point that we can make a separate application. But the first page of that letter, importantly, at paragraph 3, says, we acknowledge that neither Spain nor our clients have any right to have these letters considered by the court. Because that's what the rules provide. So, my lord, that's why I mentioned earlier, put down a marker, that the application to vary can be by the disappointed applicant as well. The disappointed appellant.
Okay.
Yeah.
2 o'clock.
Most great.
Yeah. Thank you.
All right.